Good evening to everybody. Welcome to the class of the Moot Court. You are welcome, and we are dealing the provision third. And today that we are going to deal the red cover. Yes, please read what I posted on the screen so that it will be known to me that you are hearing me and I am hearing you. Yes, go ahead. Unmute and read that what I posted on the screen.
Good afternoon, sir.
Good afternoon.
Good afternoon. International Yoga Day.
Good. So today is the International Yoga Day. Then I posted other thing also. What is that? International Music Day also there today. So these are the two things are there, and because we are dealing about the red cover, and our issue is, what is our issue? Issue is here section 16 class C is applicable to the plaintiff or oblique appellant on specific relief act or not. That is actually the issue. So here the prayer that I made it because the prayer where we can say that from the plaintiff appellant said, we are saying that 16C is applicable. In the red cover said, what you are supposed to say? In
Sir,
red cover.
respondent says.
Yeah, respondent side. Yes, respondent side, what you have to say? Section 16. Suppose if you are to prove it, then what would be the prayer there in the respondent side at the time? 16C is, can you say the applicable? Can you say the not applicable?
Not applicable, sir.
Not applicable, you should say, when you are arguing on behalf of the red color side. So, I searched the case law, one of the case law where I found these wordings are there. See, section 16 and clause C of the Specific Relief Act mandates, means it make it compulsory that the plaintiff should plead and prove his readiness and willingness as a condition precedent for obtaining the relief of the grant of Specific Relief Act. So, if a person wants to get the benefit of the section 16C, what he has to prove? Tell me. Yes?
Sir,
What
he
he has
has
to
to
prove?
prove. Sir,
Yes?
relating to immovable property, no, sir.
What immovable property? See, the
Specific
dispute.
performance.
See, the dispute over here is of the immobile property. In our problem question, not necessarily it should be immobile property, only the specific performance should be done. No, for the mobile property also specific performance could be done. So, two things that he has to prove. Number one, readiness. Number two, yes, it is there on the screen. I don't know why you are getting trouble. It is there, I screened in the screen, on the screen. Number one is readiness. Number two is
Willingness, sir.
willingness. Why you are taking that much? It is there on the screen clearly. So now, why do you have to say that? When it says applicable, we have to prove that plaintiff, sorry, defendant and here the respondent is ready for the willingness as well as the ready and to perform the readiness and willingness for the specific performance we have to say in our case. Yeah. So this court, in this case law, for instance, they have given the case law. Can you read the case law? Yes.
From where, sir?
Cursor here.
Gomati Navagam Pillai versus Palani Swami Nadar.
Yes.
Supreme 1967. In the parenthesis 1967. SCR 227. Supreme Court Review 227. All India Reporter 1967. Supreme Court 868 held that in a suit for specific performance, The plaintiff must plead and prove that he was ready and willing to perform his part of the contract right from the date of the contract up to the date of the filing of the suit. This law continues to hold the field, and it has been reiterated in J.P. Builders versus A. Ramdas Rao. In the square brackets, J.P. Builders versus A. Ramdas Rao, in the year of 2011. Supreme Court cases 429. In the year 2011, Supreme Court case within the parenthesis 4, C4, 227.
Is it
And
C4? Is it C4?
Sir, 4, sir, 4 only.
Is it 4 only?
Roman number 4, sir.
Why you are thinking? Why you are thinking it is a Roman number C? Why don't you think that it is a civil case?
Civil case, yes, sir.
Which context is good here? Can you say C40, C4, or we can say within parentheses civ means is the abbreviation civil case.
Yes, sir. Yes, sir. Civil case, sir.
Right.
C is 227 and P. Meenakshi Sundaram versus P. Vijay Kumar. Within square brackets, P. Meenakshi Sundaram versus P. Vijay Kumar in the year 2018. 15 Supreme Court cases 80 in the year 2018. 5 scale 229 page. It is the duty of the plaintiff to plead and then lead evidence to show that the evidence from the date he entered into an agreement till the stage of filing of the suit always had the capacity and willingness to perform the contract.
Yes, these three cases we have clearly mentioned over there. The plaintiff has to prove that he is a readiness for the continuance of the contract, number one. Number two, moreover, is not only the readiness, is a willingness also there. See, readiness is different from willingness. See, which will come first? Ready comes first, willingness will come first.
Willingness only comes first, sir. Later we will be ready, sir.
How the willingness?
After willing,
yeah, please.
after willing only we will be ready to do any act, sir.
If the money is not ready, then what do your willingness do?
We will stop, sir.
Then which comes first? Readiness comes or willingness comes first?
Based on the context, we have to decide, sir.
Yeah. Here, when the question of money is concerned, at that instance, first we should ready with the money, then your willing will come over there. Otherwise, if the willing is there to take it without money, then how could you say that the section 16 will be applicable to you? 16 class C will be applicable to you? We cannot say. Of course, as you said, it depends upon the context on which come first and which come right. But as per the law is concerned, they say readiness come first, later on the willingness. So the readiness and the willingness would be there in all the three cases. They said, and who has to prove?
Plaintiff has to
prove that he is ready to there and willingness and so thing. So we can, in one way, in another way, we can directly take this thing up to here. Then let us go to our thing, defendant and yes, let me make it an argument case here. Argument. And let me change the font 14 and what size is 14 or point is 14 and font is
Times
New Roman. Yes, I changed it Times New Roman. And side heading always
left side, sir.
left side, then always
Top.
Yes, always left side and always the
Stop,
first
sir.
letter. The first letter of the word is capital letter.
Should
The
be
rest of the
capital.
letters are small letters.
Does
But
not
here only one
ends
word
with
is
any,
there. Yes, please go on.
without any punctuation, sir.
Agreed.
Without any,
Next. Next.
no underline is necessary.
Agreed.
No.
Next.
First letter must be capital and
That
remaining
is
letters
already we
should be
discussed. Next.
space should be left and
That
then
is already there.
next,
Left intention. You are not
sir,
giving. You say. You should say bold.
bold, sir.
See, I made the
Para,
bold.
remaining letters should be remaining para should be not start with the same para and next line it will be started.
Automatically, then we can make it down. So here we can paste it, the entire thing, and we can make it the same font, but it is everything is bold. So from bold, I turn into the ordinary. Then justification, I did it, justified. So later we can keep the number one. That is the thing is appellant. Here we can make it out. What do you have to write it here? Whether, same thing we can write, whether WHETHER, WHETHER, whether section 16 C, here C, will be applicable to the plaintiff. We have to say the plaintiff only. Plaintiff defendant, same thing. Plaintiff and appellant are not. Are we, whatever that we used in the blue cover, the same thing we can keep it here. Or we can, if you want, you can change it in your own style also. But the meaning, the overall gist should be like this. Whether the section 16 and the clause C will be applicable to the plaintiff or appellant. What is this section? Section of, what is this section? Of
Specific Relief Act, sir.
specific CIPS, specific relief act of which year? Which year?
1963, sir.
Very good. 1963. Yes. Will be applicable or why is will be is applicable or not? Will be also, because why we should put in the future is applicable to the plaintiff, arguable appellant or not. So this way that we can make it. At that instance, to make an argument, we may cite the following cases which runs like this, this. So, and where that the section 16C of the specifically mandates, and that the plaintiff and everything that we can make it out, then it is observed in the we can make it this case law as a bold and italics. Of course, the same thing is repeated over here. Only the citation that he made it. The citation we can remove it. The citation we can keep it over there. Then after another, what do you have to do? Palani Swami. Another after what we have to put? What is the punctuation will be used?
Full comma.
Comma, then within parenthesis 1967. Suppose if you remove the parenthesis, what will happen? So, okay, I don't want to keep the parenthesis here. I don't want to keep the parenthesis because for AR we did not keep the parenthesis. Now what will happen if you don't keep the parenthesis? Tell me.
No
Tell
problem,
me.
sir.
No problem. We cannot know this. What is it? Because 1967 and 1, whether it is a 71 or spelling mistake or typographical mistake, this idea will come. So to avoid that area, then we can keep these parentheses. We can keep this parenthesis. Then it is clearly idea would be there. It is the 1967 year. Uh, 1967 year is there, and the volume is 1, and it is the Supreme Court. Supreme Court
Reporter, sir.
reporter or report.
Report, sir.
Supreme Court reports 227. See, whenever the Supreme Court reports, whenever the volume is there, either whenever the volume for the Supreme Court cases are there, when 1 or 2 or 3 or 4, whatever it is written before it, then always keep the year in the parentheses. Then what is the exact idea? Can we keep if the two citations are there? Let us see. If the two citations are there, can we keep the colon? Can we keep the semicolon?
Sir, semicolon, sir.
Generally, we keep the semicolon. We don't keep the colon here. We should not colon. It's a semicolon. Then the same case law is reported in All India Reporter, 1967 year, and Supreme Court cases 868. What is that 868?
Sir, that is a page number, sir.
Page number. So held that in that case held that the suit for the specific performance of the plaintiff must plead and prove that he was ready and willing to perform his part of the contract right from the date of the contract up to the date of the filing of the suit. So up to that extent that he should be ready enough. Then you can say his readiness and willingness to perform the contract. Where if there is not there, then 16C is not applicable to him. So this is another case law. Then we can go for this next paragraph. This law continues to hold the field and it has been reiterated in the JV Builders case law. So we can remove this thing, it's enough. The JV Builders case law, and at that instance, what you have to do is we have to keep this thing in the bold and italics because that is the practice over there. Then the same thing is there because the volume 1 is there and Supreme Court cases are there. Hence, the 2011 should be in parentheses, and later on the 424. Again, here we can remove the colon and we can keep the semicolon because the same case law will be cited in the two variation. It came in the Supreme Court cases civil. It came in the Supreme Court cases also. So 11 Supreme Court and civil. Actually, civil means you have to write full stop here. That is the right way of doing the thing because capital C and I and V is abbreviation, and whenever the abbreviation would be there, always the abbreviation will be stopped by the full stop and start by the capital letter, and the rest of the letters are the small letters. So that is an equation of the abbreviation, and hence we can say is the volume 1 and 2011 is the year and volume 1 Supreme Court cases, that is the civil, on page number 227. Then this square bracket we can remove from here, and another case law also the same thing is happened, so we can make it in this manner so that it will be quite good. So now it is again we can remove this colon to the semicolon, and we can remove this square bracket, and this bracket can be removed as now, and we can make it a bold and underline. This is called bold. I'm making the bold. Next, we should not underline it. Instead of underline, what do you have to do? Kesla.
Bold, sir. Bold and italics.
Bold, we did it.
Italics, sir.
Italics, then press the italics. So automatically it became a bold and italics, and everything is completed. Now you tell me, see, this is even myself also difficult to make it out. This 218 and the 5, what is the scale? Is it a journal? The scale. Did you observe it? See, what is the full form of the scale? Full form of the scale. So scale 229 is, I don't know why they have given. Scale 5 is 1084 and SCR journal, that is Supreme Court Reporter General scale. But is it a full form? That's my doubt. But how, if it is a full form, how we can make it out? So that is the, see here it is a scale means SCR or other journals. That is the meaning they have given. For time being, we will just ignore this one. And when something is not, we don't know it. For instance, what you have to do it? Suppose we don't know the full form of the scale. Then what do you have to do it?
Ignore it, sir.
Ignore, no, delete it. Why you need, why do you want to show the two? One is enough. Why do you want to show the two here? One is enough. Who said the two should be there? Who said the two should be there? So, when and is there, then we can remove the semicolon. Of course, it is two are there, we put the semicolon over there. Now we removed it. So, this is quite okay. 2018 within parenthesis, 15 is the volume, and Supreme Court cases, and 80 is the page. No controversy. Why I am giving these? Never write anything without knowing its meaning or hidden secret and what you are writing. It is a fundamental principle. It is a fundamental principle. Never write anything which you did not know it. So, it is the duty of the plaintiff to plead and then lead evidence to show that the plaintiff, from the date of the entered into an agreement till the stage of filing the suit, always had the capacity and a willingness to perform the contract. So, he is in all the way that he is readiness to perform the contract, but it doesn't mean that he should deposit the amount in the bank in the name of the defendant or respondent. Are you following me?
Yes, sir.
Yeah, but if he executed a what I say demand draft in the favor of the defendant and respondent, but the demand draft should be in the position of the respondent, not demand draft should be in the position of the plaintiff, and thinking that I am the readiness to willingness to perform the contract, keeping in view the draft is with him. No, if the draft is prepared over there, better you hand over to the respondent or the defendant. So this is the way we can make it. The three cases we made it. I'm sure when you made the three cases, that is more than enough. Let us see at least one more case law whether it is applicable there or not. Okay, let me see. About the importance of the proving the willingness as well as the readiness to perform the part of the contract by the plaintiff has to be shown throughout the established and plaintiff decision in the Honorable Supreme Court. In same thing is given. And if you want, you can start from here. Then you can give this the total passage so that your answer is a bit lengthy because it is only one. It is only one issue. So see Vijay Kumar and how do you write it? This thing. So make it yeah black and make it a blue. Vijay Prakash. Yes, bold. And of course, citation is not given, but if you want, we can get the citation by searching the any Indian Google search engine. But it's citation. See, when you want to remove it, it is not following. So I use another method. So this VS is the old style. Then S should be removed. Then the full stop is put it over there. And this also in the case of, better you write it in the case of IN in the case of. But it should not be in italics. Then you change the italics to the ordinary one. Yes, we changed it and continues the guidance such thus of course it is quotation. Then as it is, you write over there and. In the above cases, it is or was proved that the plaintiff and appellant, of course, those appellant not because not proven, to not ready and willingness to perform the contract because he failed to prove. He failed to prove. Hence, tell me, section 16
16C. C is not
C
applicable.
not 16 C not applicable to him.
Sir, he is not, sir.
Yeah, he is not. Yes, yes. He is, yes. See, when you are writing the paragraph, either you maintain only one tense, either a simple past you can make it out, or past tense you can make it out. But don't mix it. One para is past tense, another, one sentence is past tense, another sentence is what I say, present tense. So that will not be good because all these thing past incidents, is it not? But in
Yes, sir.
sometimes in paragraph we can make it use the present also because it was happened like that. Hence the law is now at the present it is like this, and then we can say the plaintiff is failed or plaintiff was failed to get it defense. So that is another method that we have to make it out when you are writing the paragraph. You should be very much enough in which tense that you are writing because what shows the bhuta kalamu, bhavishyattu kalamu, and vartamana kalamu. What do you say in Telugu? And it is the past and present and the future. How you can determine it in the sentence?
Based on the verb, sir.
Very
Tense.
good. I appreciate. Because even though it is not a grammar class, but it should consisting of the way you pronounce it, the way that you have to write it. Yes, so that is the way that we can make it out. Then the next component is, of course, how many cases we made the 4 cases total. It's more than enough to us, time being. Yes, what is the next component after the argument?
Next prayer, sir.
Prayer. So Prayer, prayer. So now we can make it bold. So the the front lines are common. The front lines are common. Okay, I will show you what the front lines are common. Like yeah, plaintiff defendant. Yes, I can show you. What the front lines are common? The yes, let me draw it so that we can directly go over there. Yes. So this is still we can go down. Yeah, these lines are common, which are wherefore in the light of the issues and raised and arguments made, advanced and so and so forth. This is a common. We can either use in alphabet, the capital letters, or we can you can change it to the small letter also. That is depends upon you. If you want, you can make these small letters, but see that where the capital letter comes, you should have to maintain it. So that is the prayer. In the prayer, now you tell me. You tell me what should I write in the prayer? Tell me. Tell me what should I write in the prayer? Yes.
Sir, I pray the
No,
court of
I don't.
honorable.
You don't write in the issues there. I pray because already that you made that thing. Where therefore in the so and so light of the so and so thing, you already give the introduction. Then you write exactly that what is the answer for that one. Just now I told you
The
no.
specific the specific performance act is not applicable.
Yes, you can write in any style. The specific relief relief act 1963 section 16 class C. Yes, now tell me.
Is not applicable, sir. Is not
Is
applicable to this.
not applicable. Of course, we write in the past tense. Was not applicable to the
case, to the case, to this case.
The better method is no to avoid what to write, but exactly the plaintiff and appellant.
Yes, sir.
Actually, exactly. Suppose you are in a confusion state, then parties. But parties means which parties again will come over there, because you are arguing on behalf of the
Respondent,
respondent. Hence, not available to whom?
plaintiff.
Plaintiff. This is the style you have to write it. Appellant. Appellant. Okay. Next, what are the next paragraph? Because same thing. Another paragraph also there, which is a common for each and every one. The paragraph is, yes. So this is one. And may pass an adder up to prayer. So again, I will copy it. Then I will paste it. Of course, when you make enter, it is some Roman 2. Then you have to delete it. Then you can paste it. Yes. How? See, it becomes 1 or 2. So what you do? You make another space. You make another space, line space. Now you paste it. The 1 and 2 will not come over there. Now you can keep it near. Yeah, that is the style. Otherwise, it will number it in sequence. So now pray is the end is. Letter part, what should come over there next? See, only the signed by. Okay. This is common. What should be changed? Now you tell me. So that I can change it. Okay, I will paste it. Yes, any changes over here? Tell me. Check it and tell
Sir,
me.
in the place of petitioner or appellant, we have to place the defendant and respondent, sir.
This is the thing. Instead of making, then we say defendant,
And
defendant,
respondent.
respondent. So that is the way that you have to make it out, the changes. Respondent. Then New Delhi, of course, this is the same, we can maintain it anyway. So now, this part is said to be the argument part. Is it clear? See, I saved the total thing. I did not know where it is gone. I saved it last class on Saturday, because we did it know everything. We did we did what is there, page number and acronyms. They we give the heading. Then we did the jurisdiction. Then we made the facts. Then we made the questions. All this like we did it. But anyway, that is easy to make it out again. Only copy and paste. There is no such thing. So is an argument for the moot problem 3. So other thing is very easy, because I told you only the changes we have to make it is only few. And now let me save this one so that, yeah. So the other things are very, very common over there. See, in this one, what is the changes is there if you want to make it out? Everything is the same. Same wood proposition for the red hands, red color I am speaking about. And everything it is the same. Nothing is changed over there. But only the thing it will come over. Instead of writing here plaintiff and appellant, we write the defendant and respondent. That only that we have to change. But here everything is same. Nothing changed. Only numbering will be changed. But only the thing, facts, only that say, hence this case law is from the defendant side to the appellant court, the Supreme Court of India. Only one. And the defendant here in the jurisdiction, only to make it out, the defendant, argual respondent will also submit the jurisdiction to the above court. However, and facts will say that hence the defendant approached this appeal to this court, honorable court, for adjudication of the case. And the regard the points, no changes. The same issue that you can make it out. There we can say applicable. Here we will say not applicable. Only the thing. And the arguments definitely change. See, we made an argument. Now, and prayers also, that what you argue it, because we are defending from the red hand side and the red color, hence we have to make an argument in that fashion. The prayer also comes in the same way. That 16C is applicable to the plaintiff and the appellant. So that way that we can make it out. When once you made everything, then we can go for the what are the abbreviations and acronyms used, and meticulously going by line we have to make. Of course, don't keep the full stop symbol and full stop, semicolon symbol, semicolon, no hyphen, hyphen, apostrophe, apostrophe, or square bracket or circular bracket. You need not to make it out. Except ampersand, you make it out. Ampersand that you can make it out because generally the most cases they use ampersand, that is the and the symbol that you made it, and that can be made in the acronym and abbreviations, but other things you can overlook it. But again, going to the index of the authorities are concerned, these things also meticulously go from the first page to the last pages. You will see that in the order you can make it out, like sections used, articles used, and you can also, if the books are there, your books are referred, or the acts are there, how many acts, suppose if there are many acts are there, then you can make it the list of the acts in alphabetical order. And later on, if the number of the cases are more over there at the time, then you can make a subdivision of the English cases. First you can make it out Indian cases, later on you can make English cases. But anyway, some uniformity should be maintained. Suppose if you are writing the one sequence in the blue cover, the same sequence should be written in the red cover. But again, we don't change it from up to down, down to up. And then the last point is then will come, and other things, the jurisdiction we already made it over there, so no change is there except the last line change. That is the difference between the blue and the red cover. That already I mentioned. I have shown you in the in all the mode 1, mode 2 also I have shown you. And statement of facts, because the examiner will give you the paragraph wise, and they will ask the write the written submission memorials from the both the parties. They will say it. Of course, you also give the hint as a the statement of points, or we can say the statement of questions, or we can say the statement of facts, that you will mention it. And generally, the statements of the facts and issues, how it can be represented? Yes,
Sir, statement of facts or statement of sir, question once
issues,
again.
statement of
Issues
fact
is
or statement of issues, how they can be represented means shown in the letter in the page. Yeah, the answer
sir
is
in Arabic Arabic numerals we have to in
no Arabic
arrange that, sir.
numerals. No Arabic numerals should be used over there. But in showing the page numbers, only Arabic numerals starting from the argument. But rest of the things always small Roman. So statement of the facts, when you are showing, there are, suppose if there are three statement of the facts are there. Sorry, statement of the points are there. How they can be represented?
Statement of points or statement of issues are
Did you understand my question?
no, sir.
How it can be represented means it can be shown on the paper by using the small Roman with the arrestor.
Yes, sir.
Example, example I will show you here already here. See, yeah, after the facts it comes, no. See, statement of issues are represented with the what? Small Roman one, arrestor, no full stop, and start with
Yes,
the
sir.
weather. Start with the weather. Suppose if there are three are there, let us see. So when three are there, at that instance, what you do, at the last you have to put the colon or semicolon.
Sir,
If there are
colon,
three
sir.
issues are there,
Semicolon, sir.
semicolon, then automatically here it will, suppose if you write it here, semicolon, and automatically it will be, comes number 2. Then you write it, then you put the semicolon after it, and only three facts are there. At that instance, we can keep and. We can keep and. Then third one. Then third one ended with the period, full stop. This is the style of representing the statement of issues on the paper. But if anybody if anybody, but generally I saw people use it because I felt very bad. They use it in this way. Number one, capital Roman. Capital Roman they have shown. See, this way they have represented. I don't know why it is not appealable to me. Is it appealable to you?
It is not good to see, sir. It is not good. It is
That's
not
why I say
appealable, sir.
it is not appealable to the ear. See, I will show you the both the things. Now you can decide it which is appealable, which is not appealable. Appeal to the eye. See, this is the one thing that I made it and say semicolon. Of course, I will copy the same thing and I will show you that which is appeal to the eye, which is not appeal to the eye, like which I have shown you the Times New Roman and other fonts like Calibri, which I have shown over there. So now, see, automatically it took away. So now I will make it out, say semicolon, then make it out, and then write something and put the full stop. See, both the things that I have shown you, if you compare yourself, acceptable one is the lower one. Because your eye always sees like that. Are you following me?
Yes, sir.
And in the same manner, see that as a model I am showing you. This is a model I am showing you actually. Of course, while you are making it no changes I will make it. Because for the model that I have shown you. And in the same manner, in the model which I want to show you, like if you are writing the fourth semester, how do you write fourth semester? Or sixth semester? You tell me, I will write.
V I,
Small
sir.
v or
VI.
Roman V?
Small v and I, small I.
Fifth or sixth, sorry, sixth, no. Yes, yeah. Yes, next. Next,
Next is the arrestor, sir.
semester. Next semester, shall I write? You are sixth semester now.
Yes, sir.
Then how do you refer it? You are in sixth semester. Now you tell me. Can I write it the way that as you told you? This is the way.
Sir, after V, one I, sir. After V, I.
Okay, no, okay. I will change it. Don't worry, don't worry. Okay, I will change it. This is the way that you write it. I am in the sixth semester. This is the way that you show it.
No arrestor, sir.
Okay, no
No
arrestor.
arrestor.
No arrestor. No. This is the way you show it.
Six is not appealable, sir, because in Arabic numeral is Arabic numeral with
Okay,
TH.
let me see you the Arabic numeral also. Now you tell me. Is it very good?
Fifth one, first above one is more appealable, sir.
Above one is more appealable.
Yes, sir.
And this is not appealable. Okay, I will
This
write
is
it. I will write again for your understanding. Yes, now you tell me.
sir. Third one is a more appealable, sir.
Why? Why? Huh? Okay, I will
Because
show you another thing. Now you tell me. Which is very appealable, which is appropriate, which is good.
fourth, fourth one is a fourth one is appropriate, sir,
Fourth
and
one
also
is
appealable.
appropriate. Whenever you are writing the semester, don't write small v and I or arrestor without arrestor, and don't write the Arabic numeral, and don't write even the capital Roman and th, but you write better capital Roman and followed with the hyphen. And when you're writing the semester, see that What appropriate is there? S should be capital letter, S should be the small letter. Looking at the context, you can change the style. Suppose if it is in the side heading, at that time definitely you will keep the S in the capital letter. Is it clear? Suppose if you are keeping in this is the side heading, then S should be the capital letter. Because every related first word should be in a capital letter. I told at the time. So that is the style that you have to make it out. If you want, you can take the screenshot and show to the other people. Or it is already there because I shared it and you can also see in my YouTube also. Now, why I am showing is, when you are writing also, you should be not a layman. You should be a Professor Hussain student. So Professor Hussain student not only look good, but speak good also. Not only look good, speak good, but write also good. So that is what I want to make it out to taking my efforts. But what is the use of it? Not a single person till today has shown me the memorials, written memorials, either from any one of the party. I told you frankly, you cannot learn the swimming without jumping into the water. You cannot learn it without practicing it. Sir, we will practice it, sir. It's nothing practice, sir. Okay, because if the YouTube, how do you know it? It is recorded over there. Huh? It is recorded over there. That's why that it will not be good enough to say the trade secrets. So that is the thing which I want to make it out. And
Thank you, sir.
today I completed the proposition 3 in the red hand side, that is called respondent and defendant side. And what do we do tomorrow? Can anyone will write the memorial and bring and post to me and load to my email so that and we will discuss that thing, either proposition 1 or proposition 2 or proposition 3, means moot proposition I'm speaking about. Because I took almost all, roughly I took I think 25 classes, if I not be mistaken, because it will be shown clearly over here how many I have picked it. Oh, where it is gone? It's gone somewhere. Okay, yeah, that it shows that how many classes that I made it, and that is a clear picture to you to see. Yes. See, these are all the YouTube. 1, 2 means here 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 plus 14, 28. 28 here 29, 30, 31, 32, 33, 34. On Saturday I did not make it out. 35 and today is 36. And in the semester, actually you need the 45 classes. Then you are eligible for the writing the examination. That is generally the procedure we adapt it. Generally, it is a procedure, we adapt it. Of course, it depends upon the country to country and the university to university, how many credits hours should be there if a person wants to sit for the examination. So generally, it is the 45 hours or 45 periods, rather we can use it, because period consisting of 50 minutes, and sometimes it is a 1 hour period.